those names of collections of life forms because they have a certain name for them as a collection. It's certainly better than a herd or a pack or a gaggle, but exaltation is that was always my favorite, and that's why I remember it. That's a beautiful term for a group, and larks are pretty overall. All right, we have Scott Simmons here in 24 CR 1641. There is a motion that was filed. Yeah, I don't have a date on it. We don't have a filing date on this. This thing
It just came out to us and we need to get it scanned into the system.
okay. And it appears as though the certificate of service was sent in September, just a few days ago, September 12th. And it states, let's see, you're asking to modify the bond conditions. He's charged with offensive injury to a child. Request conditions be modified so that there's no restriction on the defendant's access and possession of the child. Is this Jeremiah Simmons we're talking about?
Yes, sir.
Named in the indictment.
No, he in the indictment.
Stand by. Let me just look. Let me read real fast. This.
Yeah, this is, as the court noticed in the indictment, he's charged with a state jail felony and they've alleged criminal negligence, not an intentional knowing injury to the child. This young man and his wife have 5 children, 4 boys and 1 7-month-old little girl. The allegation occurred back in May, and it was immediately taken up by CPS and the district attorney's office there in the 279th court, and things were all handled there.
What do you mean?
The Judge Shelton ordered my client and his wife to have some parenting classes, and then after that, there was never a request by either the DA's office, who was handling the matter in the 279th, nor the Child Protective Services. There was never a request to remove the child from the home. And then on July the 10th of this year, it showed the court the dismissal showing
Here.
showing that the matter was dismissed as there was no concern. The child, when this allegation came out, my client voluntarily moved out of the house. And eventually the child, because of the the two parents work, and they have to, when one's working, the other has to take care of all the children. So the 4-year-old
How many
was,
children again?
sure,
How many children in the home?
five,
And what is
ranging
this
from age
child?
9 all the way down to 6 months. It's 4 boys and 1 little girl. It's the 6-month-old.
Well,
And-
this child's 14.
No, this child is 4.
Oh, I'm sorry, child 14 years of age or older than
Younger.
14 years of age or younger. I'm sorry. Okay. And what place is this child in the numbering of the children?
There's a 9-year-old. It ranges from the oldest is 9, then there's an 8-year-old, then Jeremiah is the 4-year-old, then Isaiah is 3 years old,
This is
and then
Jeremiah.
Abigail is 6 months old. The child was, by everybody's agreement, the child was placed with the grandmother who lived in another city, and but she's moving back here now, and it's caused all kinds of problems, as not only with the family but also with the 4-year-old himself. The grandmother is moving here, and so what's going on? The mother, his wife, works in the evenings, and then he works during the day.
Doing what?
I'm a welder and plasma table operator.
And they don't make a great deal of money, but they're doing enough to take care of their family. So while the wife goes to work, it's necessary. Their plan and it has always been that he takes over with the children while the wife is at work after he gets off work. Since there was never a concern earlier, either by CPS or the state, to remove the child, we're asking the court to, under these circumstances, to remove that restriction that restricts him from being around the 4-year-old. The grandmother, and I know that this court, and I know the court's concerned, the grandmother is going to be here, and she's going to be able to come there in the evening to help him out if the court so desires. The problem is that the mother, the wife, she doesn't get home sometimes till like midnight, because she works at Cheddar's. And so sometimes she gets home earlier, sometimes she gets home later. And so there's going to be monitoring. We have pictures. The short version from our standpoint is that this was as a result of the father roughhousing with all 4 of the boys. They were on top of him, and that's how Jeremiah he got hurt during the process of that. But a week later, I mean, we have photos to show a week later there was not any evidence of any bruises or anything. So I need to tell the court, Judge, because I know it's required by the rules of ethics. I have to tell the court, evidence that I know this court demands to know. The only prior that my client has is that he, in 2014 or 2015, he got in trouble with the federal government for possession of child porn. It was not infant child porn. It was preteen child porn. He did like 18 months, and he was on supervised release until January of this year. That is his only. The Judge Shelton knew all about it. All the state, the CPS, everybody knew about that. Judge Shelton did not think, as far as for this situation, this allegation, that was really relevant or important
Okay.
to this proceeding.
Okay. Do you have a copy of Does anybody have a copy of that judgment?
No, I don't, not yet.
That's
but
Would it
I've
happen
ordered it.
here in the Eastern District of Texas,
Yes,
Beaumont Division?
Beaumont
Yes.
Division. Yeah, it was in here. Yes, sir. I've ordered it, but I haven't received it yet. With all that in mind.
I knew it exists.
It's causing all kinds of.
Well, it's a
Family
conviction,
problems.
right? Did you
Yes,
get
sir. It
conviction?
is, it is a conviction.
Because you don't have deferred or uneducated probation in the federal system, but you have something that works like that when they just
Right.
hold everything kind of in abeyance and
The safety of the child
But-
has never been,
the point being is he's not eligible for probation in this case, is what you're saying.
not from a jury, no, sir.
Not from a jury.
No, sir. And since it's not alleged as an intentional act, it was alleged as criminal negligence, which in our opinion corroborates what the story was. They were, all the boys and the father were roughhousing, and that's what happened. And so the safety of the child has never been a concern when this allegation arose. And then he gets indicted, and then, of course, that normal condition shows up as is normal on these type of cases. And so it's causing all kinds of problems with the family and whatnot. Under these circumstances, we're asking the court to either remove that restriction or modify the restriction somewhat so we can get this problem
What kind of
resolved.
modification would there be?
Well, one of the things I was thinking about was with the grandmother coming in and monitoring, she's moving to this area temporarily for however long it takes. To
Is
be
she
here.
the paternal or maternal? Is the grandmother, is that your parent?
Yeah.
Well, that doesn't really,
Well, the child has been with her,
I
for
understand,
how
but
long?
that doesn't
For
put a
3
buffer
months.
on much.
And the mother, Princess, is up. We brought her. She's out in the hallway as well. She's with the children, who are not school age. And so we're willing to do just about anything that the court will allow in order for us to resolve this problem. And so that's where we're at.
What's Stacy?
Said the grandmother's moving here?
Yeah.
And why can't she still keep the child while this is all pending? And
Well, you want to answer that?
So Jeremiah has been kicking, hitting, and spitting, as well as not listening. When my mother took him to Walmart, he asked for a shirt. She had said no. He took it upon himself to grab a shirt off the shelf and walk out the store with it.
So the problem is the control of the grandmother, and he's just acting out because he's been away from
How old is the
his
grandmother?
brothers.
How old is the grandmother?
She is 60.
She's what?
60. No, make sure, you know.
Yeah, I don't find that too old.
I was going to say that's young as far as I'm concerned.
64 years, sorry.
Sir,
64-year-old.
is that your final answer on your mother's age? Okay. Nonetheless, I don't find that all that old either. My mother's 93. And independent.
I asked Van to come here because he was the one who handled the matter.
Okay. Well, the question goes back again to the state. What do you say? The situation here is a negligent act versus a knowing or intentional act. That makes a big difference. Negligent, though, can still, if a person is consistently negligent, that certainly can be harmful and put the child in harm's way. We're talking about a 4-year-old, right? The child was 4 when this happened.
When will he be 5?
He will be 5 in September 29th.
See, the other side of the coin is a 4-year-old, that's awfully young to be hurting a child, for a child to get hurt in roughhousing. I mean, it's 4 years old.
4
Child's 4.
boys on top of the father.
Nonetheless,
Your Honor, if I may,
I've been through this. I know what a 4-year-old child is like. The other side of the coin too, coming back here, is what we experienced in this trial that we just ended yesterday.
Yeah, you saw that in the probable cause affidavit, didn't you?
Well, you had a situation where it was pretty apparent that the child had been subject to attempts to influence one way or the other or both sides, because the child it froze completely, but had spoken before during the investigation stage. When we get to trial, it's not unusual to see what happens. There's gamesmanship being played where the families try to patch things up on their own when it had been handled, when it was not handled properly at the beginning by them, and it was put into the hands of authorities. And what you don't want is a child subject to being until this can be resolved, a child is going to be subject to influence in the home of the charged person. I mean, there can't be anything but that happening. Here's what would really make a big difference is how y'all intend to maybe resolve this, if it's going to be resolvable without a trial. If it can be resolvable, then that makes it a lot easier in all of us. If it can be resolved in a way, especially in the criminal history there, to me, is not influential in how this should be resolved. To me, from what I'm hearing, I'm more on the circumstances of this case to resolve it in the best interest of the child, but also in the best interest of the family. So that we keep a family together. It would be a lot easier on this court in making a decision based upon what the practicalities of what we know happens when a case is pending. It just can't help but subject a child. I mean, there's no way that can be comfortable. And it'd be a problem anyway if you were subject to court supervision. But I can't imagine in what's considered a negligence matter that this would be, especially a state jail, that this would be something that would last long if you were satisfactory in your behavior and it would move on. I think there's a way of moving this one without that can prevent the problems I foresee happening when you have a complainant and defendant in the same household. My question is, can this be worked out quickly?
Well, I called Sonny yesterday to initiate
He's-
this.
I haven't given him an offer yet. They asked me yesterday. I'm happy to.
And he agreed, he and I agreed we would talk about it and because I knew that would be important to the board.
I'd like to, and not to kick it down the road, but right now that's what I'm going to do. If something can be accomplished quickly enough, that's everybody can agree with and everybody feel fair and impartial with that, then we can move forward. And in this one, in this kind of situation, from what I'm reading here, my inclination is to be more than fair
Yes, sir.
when it's a negligent act. Who doesn't make a mistake?
and Your Honor, if I may, it was very slight
I know.
bruising.
Yeah, I know, but
It was
a grand
gone within
jury
4
indicts.
days.
That's the problem. You know, I know but it's still the entity that really sheds light on how serious it is. Comparatively speaking, it may be, but the district attorney's office and the grand jury agrees this is something that can subject somebody to going a bruise like that, 2 years in state jail. That's what they say he should be subject to if this is proven. So, you know, it's And you don't question them. I mean, you may disagree with them, but what happens, you gotta work with it under the circumstances and see how this can be maybe resolved in the way you have control over. Now, you don't have control over the grand jury. You don't have control over them. So what is it y'all can fashion where you have control over that you can live with that gets him and the family together, and this is disposed of in a way that fits within what you feel is fair and in the importance and aggravated nature that it should fit in versus a more serious situation.
Yes, sir.
I can't make it any plainer than that,
Yes.
because I don't want to intervene into the process, but I see what y'all want but I can't give it to you right now because there's, I'd rather not be the supervising of authority over the family. I'd rather be the supervising authority over him where we can ensure that if there's some kind of a program that's necessary, those kinds of things.
They did successfully complete parenting.
Okay.
He did
That's what we would
he did
probably
anger
do.
management.
as
Yeah,
well.
that's
He
probably, all
successfully
those are
completed
good.
that.
All of those are the kinds of things I wouldn't see there's any reason to duplicate that.
Yes,
But
sir.
what I'm saying is, I want, before the complainant and the defendant are back at the home together, that results in sometimes chaos. If there is a necessary event later that has to be taken care of, like a trial. Then you have what we have yesterday, a complete catastrophe.
I understand what you're saying.
Thank you, Judge.
I'll talk to Sonia.
Okay, can we, I don't want to spend a lot of delay on it. Can we get something maybe in 2 weeks for sure?
Yes.
Can you reset this in 2 weeks? To
Well,
get an update for me?
Well, the following Monday, we can do it this coming Monday, but the following Monday, my wife and I are visiting my
Okay, so in a week. All right, if y'all can do it in a week, great.
seminary in Florida.
Okay, if y'all can, you're talking about 4 days from today?
Yes, sir.
Well,
Well, and I'll talk to Sonny if that's.
Thursday's better.
What about